So this is BP 220, Rule 3, Section 9, which is the last section before Rule 4. It's basically Section 9, variances, exemptions. Variances from these standards and requirements may be granted when strict observance hereof will cause unnecessary hardship to the owner, developer, or prejudice intended beneficiaries, such as in the case of regional considerations, characteristics, peculiarities of the location, and other relevant factors. Rule 4. Application and approval of plans and building designs. Section 10. Approval required. No development of economic and socialized housing project shall be allowed without having complied with the standards and approval procedures set forth in these rules. Section 11. Approval of proposed residential houses of average and low-income earners. Individual lot owners who are average and low-income earners, as defined by BP 220, may construct their individual residential houses in the manner provided by these rules, provided that 1. They secure project approval from the Ministry of Human Settlements prior to their constructions, and 2. They utilize MHS-approved stock plans or they submit their proposed building plans to the Ministry for approval. Whenever applicable, the procedures and documents required under this rule in the case of other housing projects shall also be observed in case of individual residential projects. Section 12. Establishment of an integrated approval system. There is hereby established an integrated approval system which shall be applicable exclusively to the evaluation and approval of all proposed economic and socialized housing projects, whether the development is for a house and lot or for a house or lot only. Upon the effectivity of these rules, all proposed economic and socialized housing projects shall be required to secure only the integrated approval set forth herein, which shall take place of permits and clearances required under PD number 957, 1216, 1096, and 1185, and their implementing rules and regulations. Section 13. Where application for integrated approval made, applications for integrated approval shall be made with the Ministry of Human Settlements through its regulatory arm, the Human Settlements Regulatory Commission, which is hereby authorized to prescribe application requirements and impose the necessary conditions on approvals and applications. Section 14. How application made. Application for integrated approval shall be made by accomplishing in duplicate copies an application form duly prescribed by the Commission. The application form shall be accompanied by the following documents. A. Development Cost Estimated Payment Scheme for Amortization. B. Statement of potential and funding sources, preferably attested to by an accountant. C. Program of development indicating phasing and schedule. D. Locational clearance issued by the Commission. E. Certified Xerox copy of owner's certificate of title or other sufficient evidence of ownership. If applicant is not the owner, authority to develop and sell. F. At least 2 sets of sketch plan and site development plan showing general pattern and layout of development, including location of streets and proposed access roads, power and other utility lines, residential areas, and open spaces for parks, playgrounds, and community facilities. G. Location and vicinity map drawn to a required scale, indicating location, intensity, and nature of surrounding land uses within 1 kilometer radius. H. Written options to avail of the MHS stock plans, indicating specific model desired, or in the absence thereof, at least 2 sets each of the following. 1. Architectural drawing. 2. Detailed structural plans and specification including cost estimate. 3. Detailed engineering drawings. I. Certification from the Ministry of Agrarian Reform that the land is not tenanted or is not covered by Operation Land Transfer. J. Sworn statement as to nature, number, and income level of beneficiaries. Section 15. Evaluation of land development and structural design components of project. Should the project be found locationally viable, the commission shall proceed to determine whether the land development scheme and building design is in accordance with the standards set forth in these rules. Where the developer or applicant has opted to avail of the pre-approved plans of the Commission, there shall be no necessity for evaluating building design, except with respect to the suitability thereof to project site and its harmony compatibility with the land development scheme. Should the design be found unsuitable, incompatible, the developer may be asked to alter or revise his choice. The Commission may extend technical assistance in the choice of the appropriate model. Where the developer does not avail of said plans and presents his own design and specifications, the Commission shall evaluate the building components of the project as to structural, fire safety, and functionality. The review of such building plans and specifications shall be in accordance with the standards set forth in these rules. Section 16. Pre-approval of building plans. The Commission shall formulate model building plans and designs or may approve plans submitted by duly qualified professionals, which plan shall be considered pre-approved and may be utilized by the developer proponent. Section 17. Validity of development approval. Development permit shall be valid for a period of 1 year, and should activity be not commenced within said period, the grantee of the permit may apply for its revalidation within the next succeeding year. Thereafter, no development shall be allowed unless a new application for approval is filed. Section 18. Survey and approval of subdivision plans. Upon the issuance of integrated approval to an economic and socialized housing project, the developer shall refer the final subdivision plan together with the parcellary map to the Bureau of Lands for the conduct of verification survey and approval of the subdivision scheme. Upon accomplishment thereof, the Bureau shall submit its finding to the Commission. Rule 5. Registration and licensing of economic and socialized housing project. Section 19. Registration of project. No subdivision or condominium intended for economic and socialized housing shall be sold unless it has been registered and issued a license to sell in accordance with these rules. Upon receipt of the survey returns and approval of subdivision plan from the Bureau of Lands, the Commission shall notify the developer of economic and socialized housing project which have been granted integrated approval to submit the following documents to have his project registered under these rules. Number 1. Certificate of title or other sufficient evidence of ownership. 2. Affidavit attesting that the data submitted in the original application forms and attachments thereto have remained the same, or if there have been any changes incorporating therein the nature and surrounding circumstances thereof. 3. Articles of incorporation or partnership or association with all amendments thereto and existing bylaws if the developer is a corporation, partnership, or association. 4. If property is mortgage, mortgage contract, and status of loan certified by mortgagee, in addition, an undertaking by mortgagee to release the mortgage on any subdivision lots or condominium units as soon as full purchase price is paid. 5. Submit certification of availability of water supply if proponent developer intends to utilize existing water system, or permit from the National Water Resource Council if he intends to put up a centralized deep well distribution system, or certificate of water potability if he intends to leave the establishment of individual wells to lot unit owners from the appropriate government agency. Section 20. Notice of publication. Upon evaluation of the completeness and veracity of the documents submitted, this office shall cause the publication at the expense of the applicant a notice of pending application for registration and license to sell in one newspaper of general circulation in English or in Filipino, reciting therein that an application for registration and license to sell for the sale of subdivision lots and condominium units have been filed with the Commission, and that the aforesaid application papers as well as the documents attached thereto are open to inspection during business hours by interested parties. In addition, a 3x6 billboard notice of the project shall be posted on the project site until the issuance of the license to sell. Upon completion of the publication, the proponent shall submit proof of publication executed by the publisher and an affidavit attesting to the posting of the billboard notice on the site. Section 21. Registration of project. 10 days from the completion of the publication and submission of the project of publication, the Commission shall, in the absence of an opposition to the registration of the project, issue a certificate of registration. No opposition shall be entertained after the above period. Section 22. Opposition to registration. Complaints and opposition to the registration shall be filed with the Commission within 10 days from the date of publication. Proceedings for registration and license to sell shall be, in the meantime, suspended upon an initial finding that the same is meritorious. Section 23. License to sell. No owner or developer shall sell any disposable subdivision lot or condominium unit in a registered property without a license to sell issued by the Commission. Upon submission of a performance bond in the forms of a surety bond to the amount of 10% of the total estimated development cost of the project issued by a duly accredited bonding company and acceptable to the Commission, or a certificate of guarantee from any bank or financial institution of good standing addressed to the Commission for the total development cost, the Commission shall cause the issuance of a license to sell for the project. Whenever it shall appear that the performance bond is, or for any cause has become worthless, inadequate, or insufficient after the license to sell has been issued, the owner-developer shall, after due notice, be required to give an additional performance bond or replace the worthless bond within 10 days from the receipt of such notice. Meanwhile, the license to sell shall be deemed suspended or revoked. Section 24. Monitoring of project. The Commission shall have the power to monitor projects granted integrated approval and license to sell under these rules to ensure faithful compliance with the terms, standards, and conditions thereof. It may exercise visitatorial powers, and in case of violation or non-compliance of the terms, standards, and conditions set forth in the approval and the license issued, it may institute revocation proceedings and impose appropriate fines and penalty.